Good day, I'm here to discuss the case of Navotas Industrial Corporation versus German de Cruz et al., GR number 159212, dated September 12, 2005. Here the facts. Carmen de Cruz was the owner of a parcel of land located in Navotas, Rizal, with an area of 13,999 square meters, covered by transfer certificate of the title number 81574. On October 5, 1966, Carmen Cruz as lessor in the Navotas Industrial Corporation through its president Cipriano C. Bautista as lessee, executed a contract of lease over one-half portion of the said property. The lease was for the period of October 1, 1966 to midnight of October 1, 1990. The property was to be used for shipyard slipways in the lessee's other allied businesses. The NIC obliged itself to construct 2 slipways with all its accessories within the first 10 years of the lease, with a total value of not less than 450,000 pesos. On March 14, 1973, the property was mortgaged to the China Banking Corporation as security for a loan by 2 of Carmen Cruz's children, Mariano and Gabriel. The owner's duplicate of the title was delivered to and kept by the CBC as mortgagee. On December 31, 1974, Carmen Cruz executed a deed of absolute sale of realty with assumption or mortgage, in which she as vendor sold and conveyed the property to her children, namely Serafin de Cruz, married to Adelaida Cruz, Mariano Cruz, Rogelio Cruz, Sister Carmencita Cruz, and Sister Carmela Cruz, for the purchase price of 350,000, which the vendor acknowledged to have received from the vendees. In a letter dated November 22, 1976, Mariano Cruz in his behalf and in behalf of the other vendees requested CBC to conform to the sale of the property, but the CBC refused. The relations between Carmen Cruz and her children became strained. She believed that her children had ignored her and failed to take care of her. On June 27, 1977, Mariano Cruz for himself and in behalf of the other vendees presented the said deed of sale to the Register of Deeds for registration purposes. In the same letter, they requested the Register of Deeds to request the CBC for transmittal of the owner's TCT number 81574 for the annotation of the deed of sale with assumption of mortgage. On June 28, 1977, the CBC through counsel wrote Mariano Cruz informing him that Carmen Cruz had instructed it not to conform to the deed of sale with assumption of mortgage and not to surrender the owner's duplicate of the said title. The balance of the loan account secured by the mortgage was paid to the CBC. Thus, on June 29, 1977, the CBC executed a cancellation of real estate mortgage over the property. However, the deed was not presented to the Register of Deeds for registration. Mariano Cruz executed an affidavit of adverse claim stating inter alia that he and the others named therein were the advendists of the properties as evidenced by a deed of sale with assumption of mortgage appended thereto, and that to protect the rights and interests, the said affidavit of adverse claim was being executed as a cautionary notice to third persons in the world that the property had been sold to them. The affidavit of adverse claim was inscripted at the dorsal portion of the title on June 30, 1977. In a letter dated July 1, 1977, the Register of Deeds requested CBC to surrender the owner's duplicate of TCT number 81574 pursuant to Section 72 of Article 496 in order that the proper memorandum be made thereon. The Register of Deeds was obviously unaware that the CBC had already executed the cancellation of real estate mortgage on June 29, 1977. On July 13, 1977, Carmen Cruz as a lessor and the NIC as lessee executed a supplementary lease agreement. The October 5, 1966 contract of lease earlier executed by the parties was modified in that the terms of the lease was extended for another 15 years to expire on October 1, 2005. On July 30, 1977, Carmen Cruz as lessor and the NIC as lessee executed supplementary lease agreement. The October 5, 1966 contract of lease earlier executed by the parties was modified in that the terms of the lease was extended for another 15 years to expire on October 1, 2005. October 20, 1978, Mariano Cruz et al. Informed the NIC that the property had been sold to them and gave it 30 days from receipt of the letter to vacate the property and return possession to them. The vendors informed the NIC that since the October 5, 1966 contracts of lease and the July 13, 1977 supplementary lease agreement were annotated at the back of the said title on September 14, 1977. After the affidavit of adverse claim of Mariano Cruz et al. Was annotated on June 29, 1977, such contracts were null and void. However, the NIC refused to vacate the property. Carmen Cruz filed a complaint with the RTC of Navotas against Cipriano Bautista in his capacity as president of the NIC for the declaration of nullity of the July 30, 1977 supplementary lease agreement and contract of lease, and for the cancellation of the annotation at the back of TCT number 81574 referring to the said contracts, the judgment be rendered in her favor. Here the issue, whether or not that the declaring of the contract of lease dated July 30, 1977 and the supplementary lease dated July 30, 1977 as null and void ab initio. Held. The trial court declared that when defendant Carmen Cruz executed the July 30, 1977 supplementary lease agreement and contract of lease, she was still the owner of the property. As such, NIC was not bound by the deed of sale with assumption of mortgage executed by Carmen Cruz because it was not a party thereto, and that such deed was not registered with the Office of the Register of Deeds. The trial court ruled that the plaintiffs failed to prove fraud and undue influence on Carmen Cruz and or the NIC took advantage of her mental weakness. The RTC ruled that only Carmen Cruz had the right to rescind the contract of lease and supplementary lease agreement. The option to buy the property granted to NIC was supported by a consideration, more specifically the 42,000 rental payment it made upon the execution of the said contract. On July 18, 2003, the CA rendered judgment granting the appeal and reversing the decision of the RTC. The CA ruled that the appellees in the constructive notice of the deed of sale with assumption of mortgage, which Carmen Cruz executed in favor of the appellants based on the affidavit of adverse claim annotated on June 29, 1977 at the dorsal portion of the TCT number 81574. The CA declared that the adverse claim annotated at the dorsal portion of the said title continued to be ineffective and remained a lien and until cancelled. The CA held that the option granted to the appellee in IC to purchase the property was not effective because there was no consideration therefore, apart from in IC's rental payments. Besides, the CA emphasized when Carmen Cruz executed the July 13, 1977 supplementary lease agreement and contract of lease, she was no longer the owner of the property. The CA denied in IC's motion for reconsideration of the said decision. Hence, it filed the instant petition for review on certiorari. The reason that the petitioner adverse claim annotated at the dorsal portion of the TCT number 81574 was ineffective because the respondent failed to submit to the Register of Deeds the owner's duplicate of TCT number 81574 as mandated by Section 110 of Act number 496. The annotations of the adverse claim the Office of the Register of Deeds on June 29, 1977 on TCT number 81574, despite such failure to present the owner's duplicate of the said title, renders such inscription ineffectual, not binding on it and Carmen Cruz. Hence, the petitioner posits Carmen Cruz remained a lawful owner of the property. Even Carmen Cruz maintained that she was the owner of the property in her complaint, filed after the execution of the deed of absolute sale with assumption of real estate mortgage. She even executed the July 13, 1977 supplementary lease agreement and contract of lease in its favor. According to the petitioner, the said deed of sale was fictitious and in fact it was rejected by Carmen Cruz. The respondent averred that the petitioner had constructive notice of the said sale based on the inscription of the affidavit of adverse claim on June 29, 1977 at the dorsal portion of TCT number 81574. Besides, the respondent posits Cipriano Bautista even admitted having known of the said adverse claim before the July 13, 1977. Contract of lease and supplementary lease agreement were registered in the Office of the Register of Deeds. The petitioner adverse the exclusive option granted to it by Carmen Cruz under the supplementary lease agreement was essentially a mutual promise to buy and sell, equivalent to a reciprocal contract under the first paragraph of Article 1479 of the new Civil Code. But in the same breath, the petitioner argues that its exclusive option to buy the property for $1,600,000 was supported by consideration apart from the said amount. The petitioner insists that the $42,000 which it paid to Carmen Cruz as rental upon the execution of the supplementary lease agreement was advance money, which motivated Carmen Cruz to grant the option to the petitioner. The annotation of adverse claim is a measure designed to protect the interests of a person over a part of real property and serve as a notice and warning to the third parties dealing with the said property that someone is claiming an interest over it or has a better right than the registered owner. The Supreme Court agreed with the ruling of the CA that the petitioner had constructive notice of the deed of sale with assumption of mortgage executed by Carmen Cruz in favor of the respondents. The affidavit of adverse claim the respondent executed on June 29, 1977 was annotated at the dorsal portion of the TCT number 81574 on June 30, 1977. A review of the facts and circumstances in the case at bar reveals that the time the supplementary lease agreement and contract of lease, both dated July 13, 1977, were executed by and between Carmen and herein appellees. Carmen was apparently no longer the owner of the land covered by TCT number 81574, subject of this controversy. Obviously, Aphilis cannot turn a blind eye on the inscription found on Carmen's certificate of the title at the time the supplementary lease agreement and contract of lease were signed on July 30, 1977. Basic is the rule that the annotation of an adverse claim is a measure designed to protect the interests of a person over a piece of real property and serve as a notice warning to the third parties dealing with said property that someone is claiming an interest on the same or a better right than the registered owner thereof. A subsequent transaction involving the property cannot prevail over the adverse claim which has previously annotated in the certificate of the title of the property. Here the records are obvious. The notice of adverse claim executed on June 29, 1977 was annotated on title on June 30, 1977, that is 1 month prior to the signing of the disputed lease contracts on July 30, 1977. Said contracts of lease were belatedly annotated 2 months after its execution or on September 14, 1977 only, after Aphilis were allegedly warned by Carmen that her children are desirous of the property lease and their favor. To say the least this warning from Carmen should have aroused Aphilis' suspicion regarding the status of the prime property they intend to lease for another 15 years. In Section 110 of Article number 496 was the law in force when Carmen Cruz executed a deed of sale with assumption of mortgage and when the respondent executed the affidavit of adverse claim and presented it to Register of Deeds on June 30, 1977. The petitioner's reliance on the said provision is misplaced. Indeed, the Register of Deeds acted in accord with the Section 110 of Article number 496 when he inscribed the affidavit of adverse claim at the dorsal portion of TCT number 81574. Despite the non-productions of the owner's duplicate of TCT number 81574, simultaneously with the presentation of the affidavit of adverse claim. The law reads, Section 110. Whoever claims any part of or interest in registered land adverse to the registered owner, arising subsequent to the date of the original registration, may, if no other provision is made in this act for registering the same, make statement in writing setting forth fully his alleged right or interest in how or under whom acquired, and a reference to the volume and page of the certificate of title of the registered owner, and a description of the land in which the right or interest is claimed. The general rule is that a person dealing with the registered land is not required to go beyond the register to determine the conditions of the property. However, such person is charged with notice of the burden on the property which is noted on the face of the register or certificate of title. A person who deals with registered land is bound by the liens and encumbrances, including adverse claim annotated therein. The Supreme Court rejected the petitioner contention that the exclusive option granted to it by Carmen Cruz under the supplementary lease agreement is essentially a mutual promise to buy and sell, equivalent to a reciprocal contract under the first paragraph of Article 1479 of the New Civil Code, which reads, Article 1479, a promise to buy and sell a determinate thing for a price certain is reciprocally demandable. An accepted unilateral promise to buy or to sell a determinate thing for a price certain is binding upon the promissory if the promise is supported by consideration distinct from the price. So, the petition is denied for lack of merit. The decisions of the Court of Appeal is affirmed. Thank you and God bless you all.